All attendees are in listen-only mode.
Hello and good evening and good day to all of the participants on the Immigration Basics webinar. We're about to start. My name is David Sindel, and I have my partner Barbara on the line as well. Barbara?
Hi, everyone. Thanks for joining us.
We're going to speak about an hour now about immigration basics, and Barbara's going to do the intro, but I just wanted to say that we're trying to cover a topic that could take literally a day for each and every visa that we're going to speak about, but we're going to try to cover everything within an hour, so it's going to be a very cursory approach. Barbara,
Right,
go ahead.
I just wanted to mention that the presentation, can be a takeaway, the PowerPoint, and I believe we sent PDFs, but we'll probably send you an updated version. We want to make sure that you have the information handy, but for purposes of the presentation, we're not going to spend too much time on the details that are included in each of the slides. It's just more or less a reference point for you to take away with you for future use or if you want to go back to it, because within the time, as David mentioned, it's complex information, so sometimes we may not actually go through all the details during this presentation, but we will give our contact information at the end of the presentation, so if you have questions, feel free to contact us. Just to start off, the slide we have in front of you right now is just more or less the alphabet soup of the very common types of visa categories and visa types, as well as touching upon the green card process. The table of contents here just basically goes through some of the items that we'll touch upon today. And also to allow you to ask any questions. I want to welcome questions. The only thing we ask is that if the question is very specific to one particular matter, that perhaps you can contact us separately. But if it's a general question or a question about timing issues or a broader question, we're happy to answer. So feel free to ask.
There's on your control panel, there's actually a question box where you can send your questions. So we will be monitoring those during the webinar. So when we sort of have a chance in between slides or perhaps at the end, we can answer as many of your questions as possible. Okay. Barbara?
Okay, jumping right in the next slide.
Yep, we're on.
So we want to start off with talking a little bit about the visa stamp I-94 versus the approval notice, since this is a topic that definitely most people are a little bit confused about. I think the first thing to remember is that when you actually have a foreign worker who has a visa, when they talk about visa, they normally talk about the visa stamp that's issued by the U.S. Department of State outside of the U.S. that is more or less like a key that allows the foreign national to enter the U.S. It doesn't necessarily grant them status. The I-94 document, which is now online, is the document that determines their valid state. Now, there are exceptions to this. For example, as students, they have what they call duration of status, but most H-1Bs and non-immigrant workers in the U.S. actually have a specific date that they're here legally until, and that's their I-94 status. Now, a 797 approval notice, that document is issued by the USCIS, and that just grants them the ability to be in a specific status, but not necessarily grant them that status if they're outside the U.S. at the time it's approved. So the I-797 notice is a document that is helpful to refer to determine whether someone has been granted the ability to gain status. But we always want to look at the context for which the status is granted. For example, if it's an extension, and they're already physically here, then we do look to the I-797. However, they subsequently travel, we always refer back to the I-94. So these are some of the things just to keep in mind when you're looking at paperwork from foreign workers, or if you're a foreign national yourself, just to keep that in mind, because sometimes you think, oh, my visa's valid, but hey, my passport expired, a year before my visa expired, and then you think that the last time you entered, you were granted status until the validity of the visa, but in fact you're actually limited by your passport. So this is something just to be aware of.
Okay. So, just a note, just an easy way of understanding the way the visa stamp works. The visa stamp is kind of a ticket to enter, but the I-94 is your actual permission to stay, and it tells you how long you can stay. And the I-797 is kind of like the approval notice that allows you to buy your ticket. So it's kind of like the first of all, and this is not true in all cases. There's certain visas where you don't need an approval notice and you can obtain the visa directly at the U.S. Embassy. But in some cases, you have the I-797, which allows you to get the visa stamp. So that's just an easy way of understanding it. We're going to go now to H-1Bs. An H-1B is a specialty occupation visa. A lot of you probably know about what an H-1B is, but I'm just going to go over it for those who don't. One of the things that you need to remember are what is a specialty occupation? A specialty occupation is an occupation that requires, in order to do the occupation, a bachelor's degree in a specified area of study. So that's really important to remember. You essentially need a bachelor's degree and it's in a specialty area in order to do the job. And the person applying for the H-1B actually has to have the bachelor's degree in that area of study. There are exceptions. Sometimes if you have work experience, you can sort of do what's called an evaluation of your work experience to obtain an evaluation deeming your work experience when combined with your studies the equivalent of a major. And that's something that we do on a regular basis. But essentially, you do need to have, again, a bachelor's degree. The H-1B is something that is for up to 6 years. At any one time, one can obtain up to 3 years of and a single approval notice, and one can change jobs with an H-1B as long as you apply for a new H-1B, and of course, the same uh, requirements must be met when you apply for the new H-1B. In other words, you must have a bachelor's degree, and you still need to have the area of study has to be in sync with the specific job. So every time you apply, you still have to fulfill the same criteria, but one can apply any number of times if they want to switch jobs. And just an aside, this is getting a little bit more into detail, but if you do change jobs and you apply for a new H-1B, you don't actually have to wait for it to be approved to start the new job. One of the things that's really important in the H-1B context is the wage. In the past, the U.S. government has been very, very strict about looking at what someone is paid as an H-1B holder because they're concerned about displacement of U.S. workers. So there's something called a prevailing wage determination, and part of that process is actually the employer needs to substantiate to the Labor Department that the wage being paid to the employee is the sort of the minimum wage for that job in that metropolitan statistical area, in that state or in that city. So, if you're, for example, a computer engineer in Silicon Valley and just starting an entry level, the wage may be $60,000 or $70,000. If you're an engineer in Chicago, it may be different, and if it's in Mississippi, it's probably going to be lower because the wage levels are lower there. So,
David, can I ask you a quick question?
Sure.
Let's just say that you have, a degree that is not a perfect match for the offered position. You
Yes.
mentioned something about, getting an evaluation. Can you tell us a little bit more about that?
Right. So essentially, if there's something called the 3-for-1 rule. So if you have uh, essentially 3 years of experience in the specific field that you're applying for, that can be used in lieu of 1 year of university study. So, for example, if you have an associate's degree, 2 years of study, you would need to show 6 years of experience in the specified area and be able to substantiate that through letters from former employers, and then do an evaluation, which is basically a university professor who can grant university level credit that will attest to your experience.
Got it. Okay.
So I do have one question here, Barbara, that I'm going to take just briefly because it goes within this. There's someone who's asking about cap exempt H-1Bs. Can any nonprofit organization apply for this type of visa? The answer is no. They're very specific. So basically, we haven't talked about the cap, but I'll talk about the cap first. One of the biggest problems with the H-1B is that there is a cap for the H-1B. And the cap is essentially 65,000 workers per year for the bachelor's degree category. And if you happen to have a U.S. master's degree, it's 20,000. And that cap has been oversubscribed. More people have applied for the cap than visas are available for the last, at least as far as I can remember, 4 or 5 years. And in the last couple of years, it's been about triple that. So the people, even if you apply for an H-1B and there's a specific period for applying for that, the chances of actually being selected, depending on if you have a bachelor's or a master's, can be as low as 35% or something like that. So this cap thing is really, really important in the H-1B category. And there's a couple of exceptions to it. One is if your organization is a nonprofit organization that is affiliated with an institution of higher education, a university, a college, something of that matter. There are other exceptions, government research organizations, and so forth. So the answer is no, not any nonprofit can be cap exempt. There are very specific affiliations, usually with universities, that are required. Barbara, I think you were going to take the next slide.
Yeah, you touched the next slide is really a little bit more
right.
in-depth information about the specialty occupation. And as David mentioned before, the H-1B cap does impact the ability of companies as well as foreign nationals to get H-1B status. So looking into other options is always a good idea. But with regard to the basics, David already mentioned the specialty occupation requirement. Maybe we can move on to the next slide, David.
Yep.
The next slide, David.
This one?
David?
Yes?
Yeah, that one. So, going back just to one more before, if you just want to go back to the previous one, I just want to give you an idea of the broad nature of, just the type of positions as well as the type of sponsors and the information for the qualified candidates. If you look at this chart, it gives you an idea about how wide-ranging the H-1B category can be. Now, for some foreign nationals, if you get a degree in a specific field, it's pretty much a given that you're going to be working in a particular area. But, for example, you may have someone who's in business administration or the arts, and sometimes that they may actually end up working in a different field than what they originally studied in college. So you want to make sure that you do have, take a look at the entire picture of the foreign nationals' work experience as well as education to determine what category they would fit under. And this is a kind of a good idea of what the categories can look like. The next slide, David.
Yep.
So I think we're talking a little bit about how long someone can be in H-1B status. And David, do you want to go ahead with that?
Sure. So basically, as I said before, initially 3 years. You can get an extension of stay for an additional 3 years, and then the maximum period is 6 years. But there's one big exception. If the employer applies for permanent residence through either the PERM program or in other means, at least 1 year prior to the expiration of the 6-year period, the H-1B can be extended in 1-year increments, and in some cases 3-year increments, depending on where the green card process is. So that's an important thing to remember
Right.
because it allows individuals to extend. Did you want to talk about prevailing wage determination?
Right. So let's jump to the prevailing wage, but just a little bit of mention with regard to the timing. You may have foreign workers that come to you who may have already gained a couple of years of work experience in H-1B, and maybe they're looking for sponsorship for a green card, or maybe they've already had an employer that sponsored them for a green card and have reached a certain stage of the process. As David mentioned, you want to look at the entire picture of their immigration history, because sometimes they may seem to be a great candidate and they have the necessary experience, but you weren't planning on sponsoring them for a green card immediately upon them starting or joining your company. And you want to make sure that you're careful about the timing of that, because if they do join your company and they only have 1 year left, you may be forced to deal with either starting the green card right away or even losing that worker if they can't gain the ability to continue employment in the U.S. With regard to the prevailing wage, David touched upon that a little bit, but this slide is just a little bit more information about how the Department of Labor looks at prevailing wage and where you can get the wage data. So we gave you a link to that as well, and the basic idea is that the U.S. government's goal is to prevent the hiring of foreign workers to depress the wages of U.S. workers. They always look to make sure that the position and the requirements for that particular role, if you hire a foreign worker, you're not undercutting what you would actually pay a U.S. worker for this job or what the government prevailing wage is. And that's really the ultimate goal of having the prevailing wage determination for both the H-1B and for the green card case.
Right.
The next slide, Dave.
Okay.
So this slide just goes over a little bit about what David mentioned, which is the limitations on H-1Bs. And as you can see here, the U.S. quota for the H-1B cap right now is at 65,000 minus the Chilean and Singapore set-asides. And there's a 20,000 set aside for U.S. master's degree holders. One thing to remember is that the U.S. master's degree doesn't necessarily need to be related to the field that the person's actually working in. So for example, if you have someone who has a bachelor's in engineering and then an MBA, but you actually need the foreign worker for the engineering skills he or she has, that would be fine for purposes of meeting the master's degree cap numbers. So basically, if you have a foreign national that has a U.S. master's degree, they are in some ways at an advantage because they get the benefit of the extra 20,000 numbers that they may be selected under that original cap. Now, if they're not selected under that, then they would fall within the regular 65,000.
Exactly. And then again, cap exempt. So if you have currently have an H-1B or have been counted against the cap, in other words, you've applied for an H-1B and you've had an H-1B within the last 6 years, you can apply for a new H-1B even if you've left the country. So this is kind of a point that a lot of people don't know. But if you've had, say you had an H-1B 3 or 4 years ago for, say, a year, and then you went back to your country and you happened to find another job, you would not have to go through the cap again. You could do what's called like a remainder, a recapture of the time that you lost. So in other words, if you had used a year, you could actually get back the 5 years that you still had in the H-1B. And that's an important point for former H-1B holders that may have changed other statuses or no longer in the U.S. So it's something that you should definitely keep in mind. So going to the next slide.
This is about the deadline. And the H-1B deadline, and what we mean by deadline isn't that the H-1B will be approved on April 1st, but for every fiscal year, which runs from October to October, the earliest date that an employer may file an H-1B cap subject petition is 6 months prior. So that would be April 1st of that particular year. The effective date of the H-1B is actually October 1st of that year. So when we mention the deadline April 1st, that's just for the most recent upcoming cap that we're going to be looking at. And what that means is if you have students that are out there that are looking for jobs, You may want to keep that date in mind for purposes of getting that employer to sponsor you. And it would be in advance of April 1st. We normally recommend starting in February or even as early as January, just to consider the timing of it, because you want to have the case and everything else ready if there's an evaluation needed, if you needed letters from other employers to justify a dual major or something like that. You want to be sure to start early to take a look at all the issues that could come up and plan ahead so that we can file any petition on April 1st.
Okay, Barbara, am I taking this or are you taking this one?
There you are.
Okay, so generally for an H-1B, there's several types of employment that are valid. There was a memo several years ago that sort of described what kinds of H-1B employment relationships were okay. Obviously, traditional employment, where you work somewhere, you go to the office, that type of thing. If it's an occasional off-site employment, that's okay as long as the employer has control over the employee. Long-time permanent place off-site employment is also okay, but that also deals with control. If you have someone who's self-employed, now we do get questions sometimes on that. Generally, self-employed beneficiaries are not allowed if someone happens to start their own company, but they're not a major partner in the company or major shareholder, or they have an independent board of directors. There may be exceptions, but generally it's not allowed. Independent contractors, you must be an employee of the company to have an H-1B, no independent contractors, and you can't have what's called a third-party placement job shop kind of scenario. So you have, like, for example, a personnel placement agency sponsoring you for an H-1B and placing you into some third-party operation where the placement agency only just pays the salary of the H-1B employee. That would not be acceptable either. I'm going to mention this one, although it's getting into more specifics. There was a recent decision by the CIS that when an employer does have an H-1B and they change their work site to an area outside of the metropolitan statistical area where the current H-1B employee is supposed to be working, the USCIS requires a new, what we call an amended H-1B petition and a new labor condition application. So it just makes it a little bit more onerous when someone changes the location of their job. So sometimes companies have more than one location, and if they change, like, not next door, but in a different city, for example, the requirement would be to file an amended H-1B petition in that case. I'm going to going very quickly now, I'm going to talk about L1s. L1s are visas that are applicable to organizations where there's a qualifying relationship. Okay, it means basically that you must have a company abroad that owns at least 50% of the US entity. And you have to have worked for that company for at least one out of the past 3 years in either a managerial or specialized knowledge capacity. So if a lot of people say, well, I'd like to get an L1, my parents have a company. If your parents have a company and you create a subsidiary in the US, as long as you've worked for that company, it's fine. If you've been living in the US for the last 3 years in F1, it is not fine. So that's important to understand. If you do get an L1 and you have a spouse, the L2 can gain work authorization. They can work in the United States and obtain what's called an employment authorization document in EAD after entering the United States. So those are really important kinds of information. This slide is basically gives you some very specific information about the L1. Again, going quickly, corporate relationship. the qualifying capacity, is the person a manager? Specialized knowledge is a very, very complicated, defined standard. It generally means knowledge beyond and above what normally people would have in your industry, and usually specific to the organization. That, in other words, say, for example, a software program that the L1B person helped develop, and that was a software program that the company actually developed. Something that is very connected, some sort of process. That would be an L1B. It's just being a computer programmer working in a company abroad would not qualify you. For an L1, you need to process with the USCIS unless there's what's called a blanket L1, which sometimes is available for larger companies. The 1 out of the 3-year test is important, and of course, the kind of like the H1B, the employer has to have control. The L1 for the manager can be up to 7 years. Specialized knowledge for up to 5 years. You have here what is defined as specialized versus advanced knowledge. That's something you can read. And what's interesting about the L1A specifically is that if you qualify for the L1A, you can apply for what's called the EB-13 for a green card on the other side. So if, for example, if someone comes in L1A and they have managerial experience in L1A, they can then later apply for EB-13 and bypass the labor certification process. So essentially, it makes getting a green card a lot faster. Usually within a year or so, someone can obtain permanent residence from L1A to a green card. So again, making sure the person has the experience. If they're interested in permanent residence, it may be prudent to choose the L1 if they have the choice. And do they have specialized knowledge? And then lastly, the L1B specifically, well, all the L1s in general, but the L1B specifically has been a target for a lot of scrutiny by USCIS, and approximately 60% or 60 some odd percent of the L1As are issued what's called an RFE, which is a request for evidence, asking questions about the case, and they're usually very onerous, 5-10 page requests for evidence. So something to keep in mind when you're doing an L1A or an L1B. Barbara, did you want to talk about TNs?
Yeah, I do. But just one more final thing about the L's, as before we jump into TNs, is that if you are, in a position where maybe the H-1B didn't work out, or the company wishes to keep you, one workaround can also be to have you work abroad for a subsidiary or affiliate or branch office outside the U.S. if they have the corporate interrelationship. I think some companies may have that ability, some may not. But it's just something to keep in mind as a potential workaround as well. And then the TNs that I'm just going to touch upon here is only available for individuals that are citizens of Canada or Mexico. And as we mentioned, the TN visa category is really based on the North America Free Trade Agreement back in, I believe, established quite some time ago. And right now they have the visa requirement for Mexicans still exists, but for Canadians, they're visa exempt. So if they fall within one of the enumerated categories, the position that's offered to them meets those requirements, they can actually come to the U.S. and start working for a 3-year duration without the limitation about timing, like the H-1B, or having to apply for a visa. And as I mentioned in the bullet here, we just want to also indicate that this applies to Canadians, but Mexican citizens do need to actually get a visa first. So they have to go through the U.S. Embassy and consulate, get the visa, and then they can come into the U.S. The next slide, in David. is the list of the TN, most of the common TN occupations. As you can see here, again, it's quite broad. There are many categories for the TN, but one thing to remember is, unlike the H-1B, the evaluations for degrees normally do not apply for the TN. So, for example, we usually have someone who has the enumerated degree requirement for that particular category. That's how they would qualify for the TN. But if, say, they don't, and you need to do a work experience evaluation, that wouldn't work for the TN. But it's one of those options that you can use if you have someone who is a citizen of those countries.
And just something to remember, the TN is issued for 3 years. You can get it at the border. It's relatively inexpensive versus an H-1B. And certainly, unless the person is looking for immediate permanent residence, I personally would choose a TN over an H-1B anytime if the person is being offered one of the positions on this list here and has good qualifications.
Good point. Yep.
Okay, yep. O1s. Barbara, are you taking this one?
You are.
I am? Okay. So with respect to O1s, we have three different types of O1s. One thing to remember about the O1 is that there are very specific criteria that need to be met. Some people say, I'm an artist, I want an O1, or I'm, a famous actor, and I think I should get an O1. Unless you really have extraordinary ability or extraordinary achievement, and you're kind of at the top of your occupation in terms of your background, it doesn't work so well. It's really important to have a well put together portfolio, resume, and being able to define what area you are actually a extraordinary ability in which you're an extraordinary ability person. Um, I think the trick in trying to get an O1 is not just saying, I'm an artist, because that's very broad. But if you're a specific artist in a specific area and you can show that you're at the top of your field by defining the field in which you're working, you can have a better chance of obtaining an O1. It's a great visa. Yes? Mhm.
Just ask you a quick question about the O's, because I think one of the things a lot of folks may be wondering is how many years of experience do you really need, and is it something that we can measure about timing? Because say they're working for Chanel, or they're working for a well-known company, is that enough for them to get an O? Is that enough for them to actually meet the criteria?
There's no specific number of years that someone has to have experience. There's no statutory requirement. I've processed and successfully obtained O's for people with 3 or 4 years of experience that have done a lot. And then you could have people on the other end of the spectrum that have been working for 20 years but would not qualify. Working for a well-known organization can certainly help in obtaining an O and fulfilling one of their criteria, but it does not, in and of itself, qualify you for the position. Right.
Got it.
Okay. The in the arts, extraordinary ability in the arts means distinction, a high level of achievement, and recognition substantially above that ordinarily encountered, to the extent that a person described as prominent, is renowned, leading, or well-known in the art field, in the fields of art. That's what the criteria is. And there are lists. There are lists of specific criteria that need to be proven in order to obtain an O1. Obviously, if you have an Academy Award, an Emmy Award, that sort of thing, you can basically count on getting an O1 without any difficulty, but most people don't, and so they have to fulfill one of the three criteria that's on our slide here. And I'm going to go through this very, very quickly. Performing services as a lead or starring participant, achieving national or international recognition for achievements, performing in a lead, starring, or critical role for an organization, critically acclaimed success, having a record proving that you have success, commercial success, showing like box office receipts. In this day and age, maybe you may not have that, but certainly other showing, like through blogs and through the internet, sometimes through sales, whatever it is. Receiving significant recognition for achievements from organizations and a high salary. So you need to prove basically three out of these. The three could be what we usually do when we do an O1 is we try to show more than three because it's the government doesn't always recognize or agree with everything that you say. So you always try to make an argument that you qualify for more than three, hopefully all six. And that's generally the way we do it because that obviously increases the chances. Um, Motion picture, again, high level of accomplishment, significantly above that ordinarily encountered. You need to show someone that you're show the government that that you're extraordinary. Individuals qualify for the O1 category, not groups. People that are affiliated with the O1 can obtain an O2. So in other words, people that are sort of essential to the O1's activities can come in an O2. The O1 is generally granted for an event, a lecture, a tour series, or ongoing engagement like employment. So it's basically pretty broad that way. You cannot freelance as an O1. This is something that a lot of people ask about. You cannot freelance as an O1. You need to have an employer or an agent. An agent is kind of specific to the O1 category because usually, in the non-immigrant context, you have employers. You need employers. This specific category allows for an agent, someone who basically represents the O1 visa holder, and you work through that agent in doing any of the activities that you want to do as part of the O1 visa. The O1 is for up to 3 years initially and can be extended in 1 year increments, assuming that you have the same employer. If you change employer and activities, sometimes you can obtain another 3 years instead of 1 year. But generally, it's 3 years and then 1 year increments. And from the O1 category, you can go into a green card very easily, kind of like what I talked about earlier from the L1A to the EB1-3. There is something called EB1-1, which has essentially the same criteria as the L1 and would allow someone to obtain permanent residence fairly quickly, again, within a year or so, as opposed to 2-3 years through the regular process. So that's something to keep in mind. If someone's interested in permanent residence in O1, it's probably a good way to go.
Yeah, just one thing about the extraordinary ability, and David, just to highlight that, sometimes people may meet all the criteria, yet their O1 may not be approved, or the government may issue a request for evidence. And one of the things to keep in mind is that the government also looks at the totality of the qualifications of the foreign worker or foreign national. So I think, as David mentioned, you need to meet the criteria. However, just keep in mind that, the more criteria, the longer or the more prestigious the experience and the work that you've done, the more likely the O1 will be approved. And then when you get to the extraordinary ability level for the green card, the criteria tends to be a little bit higher as well. So a couple of things just to keep in mind if you're thinking about this category.
Yes, and they're a bit flexible when it comes to recommendation letters. We do certainly provide recommendation letters for O1 people, and we try to fit everyone into the criteria, but they do look at the whole picture as well. So I think that's important. I'm going to go on to the H3 now. The H3, this is a trainee visa. We're going to talk about H3s and J1s in a bit. The H3 is a visa that I used a lot maybe 10 years ago and a lot less now because there's a higher level of scrutiny for them. And what's important to understand is that it's training, but it is training that cannot involve productive employment. It has to be kind of classroom training. And on-the-job learning has to be minimal. So these are criteria that need to be met in order to obtain the visa. And a lot of times it's hard to prove these things. Specifically, the next criteria, which is the program must be unavailable in the trainee's home country. So it has to be specific training to the company or to the United States. And it has to help, the training has to help prepare the trainee for a career outside of the US. So if they don't have, if the employee doesn't have a specific plan in the US, I'm sorry, in their country after the completion of the H3, it may be problematic as well. These visas are good for up to 2 years. If you stay the whole 2 years, there is a 6-month foreign residence requirement. And sometimes we have people that do the H-1B lottery and then try to apply for an H-3 afterwards. That can raise a lot of eyebrows at the government level because they were applying for work and now they're all of a sudden they're deciding to trade. So it may raise a red flag. And that's why a lot of times we don't use this visa, but there may be circumstances and we do them, but not so often. Barbara, did you
So
want to add
David,
anything?
would it make sense if your company didn't have a branch office outside the U.S. to consider the H3 for a foreign national?
It would make sense if there were some sort of affiliation with a foreign company. If, for example, there was some sort of exchange set up between a company that wasn't necessarily a branch or subsidiary, it may work, but it becomes more tenuous.
Got it.
Okay, so Barbara, you have J1s?
I'm going to talk a little bit about the J's, and given the time, we just want to touch upon it. The J1 visa is kind of another broad category where the overall goal is to have cultural or international exchange between the U.S. and the foreign country from which the J1 applicant is actually coming from. The categories include interns, research scholars, students, specialists, even au pairs. So as you can tell, trainees as well. It's quite broad. It's basically designed that there's an element of it that's not just them coming to work in the U.S., but really just to absorb U.S. culture, to learn about the culture, to actually eventually go back to their home country, and to broaden the scope of international exchange. That was the purpose of the J1. The next slide, David. So in order to qualify, David, the J1 provider, the program must first be approved by an authorized J1 organization. I think you need to keep in mind that there are also organizations that provide assistance with getting the J1. So your company or maybe your employer, they don't necessarily need to be the authorized organization. They can actually use an outside umbrella program provider. The J1 holder has to speak English. Normally, if you graduated from U.S. university, the J1 isn't one that you would qualify for because normally they require a foreign degree or a related field of experience and a related field of experience for at least 1 year. And then some J1s are required to go back to their home country. The next slide. Now, with academic training, we sometimes do see J1 students that are here in the U.S. attending a university, and they're eligible for employment. And as I mentioned here, the 18-month maximum for undergrads for pre-doctorates. I usually see J1s for students that are going through a doctorate program. There's flexibility in terms of the duration of their studies. Normally, it's a 36-month period, and if the studies are less than 36 months, it would be less time. And then you do need a letter from the school itself in order to qualify for employment under the J1 category.
Barbara, would you think that would small companies also qualify for the J1, or what what are
That's a
the
good.
umbrella organizations looking for in terms of employer criteria?
Yeah. So the J1 criteria does vary, but a lot of the smaller companies can qualify for a J1. And normally, I would say if a company is not sure, probably to go ahead and contact us or contact the J1 umbrella program, and they'll tell you. They usually require a site visit to visit the facility where the J1 trainee or intern is going to be located. They want to make sure that you exist. One of the things that is important is that the actual J1 umbrella organization or the organization, either the employer or an outside organization, is responsible to report back to the U.S. Department of State. And their liability stems from their overseeing the actual administration and making of the J1 program to make sure that whatever is listed as what the intern or the trainee is going to be doing, they are actually doing those things. So the size of the company isn't necessarily the only thing that they look at, but you also want to make sure that the requirements for the training is actually adhered to. For example, some companies have outings, cultural exchange outings, where they actually take people that are interns out to events like baseball games and picnics and things just to expose them to the U.S. culture. So that's part of the requirement for purposes of the J. But in terms of the size of the company, that's not the only criteria they look at.
Exactly. Okay, so I'm going to go into e-visas. So e-visas basically are only for country individuals that are coming in to work who are nationals of certain countries that have a treaty with the United States. If the company that an E1 or E2 person would be working for would need to be a company that is at least 50% owned by a nationality that's recognized under the treaty, and the individual coming has to be from that same country. Generally, in e-visa for there's E1s and E2s. So an E1 is essentially a visa that has whereby a company has substantial trade between the U.S. and the applicant's country. Substantial trade has to be at least 50% of the trade occurring between the U.S. and the applicant's country. So basically, it means that, and trade is defined in many, many ways. So it's important to understand that it may be intellectual property trade, it could be services trade, it could be actually items, things that are sent from the anything really, electronics, semiconductors, you name it, that could be traded back and forth from the U.S. And that country. So there has to be substantial amount. The substantial amount isn't really defined by statute. It's really determined by, in this case, the U.S. State Department, because e-visas are generally applied for at the U.S. Embassy having jurisdiction over that nationality. So if you're a Japanese national, you're going to be applying at the U.S. Embassy located in Tokyo or in Osaka. And you're going to have to show and prove to the U.S. Embassy in one of those places that you have substantial trade. The number really isn't set in stone. You know, over the years, I look at about $1 million a year as substantial trade, but it could be less and it could be more. Um, E-visa, E2 visa, again, same thing. You have the applicant's country has to have a trade agreement with the U.S. and there needs to be a substantial investment into the United States to create U.S. jobs, and it has to be substantial. And again, that number isn't defined by statute. It depends on the type of business that the company is engaging in, and it depends on the area where the investment is being made. For example, a restaurant in New York, that could be a substantial investment if one were to spend, say, $300,000. But that same restaurant in San Diego could be, half of that. That could be enough. So it's very hard to give anyone specific numbers as to what constitutes a substantial investment. The e-visa is a great visa because you can obtain it for up to 5 years at one time, and it's fairly quick to obtain if the company is already registered as an e-visa company with the U.S. Embassies where the application is being sought. So it's something that we use in our firm a lot, only because we handle a lot of Japanese nationals, and that's probably one of the countries that uses the e-visa the most. If you're working for a U.S. company, you're not going to qualify for an e-visa. So it's just something to consider, and there may be specific cases where an e-visa is something to look at. B visas. B visas are generally visas that one obtains to visit the United States, or to come for business to the United States. If your country is a visa waiver participant, which includes most of the Western countries in the world, Japan, Korea, Australia, then you don't need a B visa to enter the United States. You can come in on what's called ESTA. But if your trip has specific intentions that may not be clear to the port of entry when you enter the United States, or if you're not from a country that has the visa waiver program, or if you need to spend longer than the 90 days that you're granted on the visa waiver program, you want to think about a B visa. And basically, there are specific statutes that govern the kinds of activities that are allowed. And it's very important, if you're coming on business, to be able to differentiate the concept of working in the United States, which would require a work visa, and this is not a work visa, and coming in to the United States on a B1, which is conducting business activities on behalf of a foreign entity and not working in the United States. You can be setting up a company, you can be, coming in to oversee what's going on in the company, to report back to your company abroad, but you cannot be working, and you certainly cannot be paid by a U.S. entity when you're in B visa. Okay, so
So David, we have a little bit less than 10 minutes left, and I just
yes,
want to mention, with regard to the B visa, like you mentioned, sometimes we do have the option of maybe bringing someone over on a B1 in lieu of H1B,
yes,
or B1 in lieu of H2B, but those are sort of carve-out categories that, on an individual basis we can explore as needed. I think I'm going to touch upon the immigrant visa options pretty quickly here. Because I think, David, as we mentioned already with the green card cases, those are usually the first step is really just to get the person work authorized in the U.S. Most people don't jump directly to the green card, but David's going to talk a little bit about the different employment-based categories on the next slide, and then we're going to wrap up on PERMs and priority date issues. So, David, you want to talk about the
okay.
preference category?
Right. So essentially, for legal permanent residents, there are three preference. There are actually five preference categories, but we're going to talk about three of them. The first one is the one that I touched on earlier. People that are multinational managers, executives, extraordinary ability people. Second preference is generally, and there are lots of different carve-outs within this, but generally someone who has a master's degree, and the job requires a master's degree. And the third preference is for skilled workers or people with or professional workers, those that have a bachelor's degree as well. And the importance of they're not sort of like separate green cards. They all lead to the same green card. The difference is that some have different have different quotas and waiting times. And then in the first preference, there is no need to obtain labor certification. And that's what we're going to talk about in a minute. It's called PERM. and it makes things go a lot faster. So if you can get into the first preference, it just makes things go faster. If you're in the second preference, usually there's less of a wait than in the third preference. And then the third preference, there's more of a wait. Waiting times, we're going to talk about it in a bit. It changes all the time. We've had times where and depending on your nationality as well, because if you're Indian, it could take 7 years for an EB3 or 5 years for an EB3, and if you're from Japan, the same EB3 could take 2 years, and it just depends on the nationality. They're usually Indian nationals, Chinese nationals, and sometimes Filipino nationals have to wait longer because there's a lot of people applying. So in terms of the process, first you have the perm, and Barbara, you're going to speak about the perm?
Yeah, I'm just going to touch upon the perm process. So the next slide. David, the next slide.
Yep.
It gives you a visual, very similar to the visual you just saw. And the reason why this is helpful is that if you look at stage 1, that's where most of your foreign nationals would likely start off from. However, as David mentioned, if they're qualified for the EB1 category or even the national interest waiver, they can probably slip over to stage 2. And depending on priority date, which we'll talk about in the last few slides, they may actually be able to move forward with the green card last stage 3 of the process concurrently. So the next slide is just about the first preference. David, I think you can probably see that one. The next one, please.
Yes, please. So EB1.
Right, that one David already mentioned that that's labor certification is not required. If you move on to the next slide, these are the 2 categories. The next slide will show you the 2 categories where the labor certification is required. And the basic concept is that you have to test the U.S. labor market. And what does that mean? That means basically the U.S. government is trying to make sure that the employer adequately reviews the availability of U.S. workers for the role, and the role which you're offering to a foreign worker at a specific wage level, to make sure that there aren't any U.S. workers available. Doesn't matter if the foreign worker is qualified, doesn't matter if the foreign worker has more experience than the U.S. worker. The process itself isn't aimed towards giving the best candidate the chance for the job. It's really to make sure that the U.S. workforce is reviewed and protected in the sense that a qualified U.S. candidate is offered the position. So the next slide goes through a little bit of the timing and processing of the perm application. Right now it's and it's a wholly electronic-based process. So the first step is to file the actual application with the Department of Labor. But the first step was the prevailing wage step, which is the second bullet here. The prevailing wage determination is usually issued by the U.S. Department of Labor in about 60 days. And then there's a wait period about 30 days for recruitment. And then the processing time for perms is about 6 months. So in terms of timing, you're really looking at probably about 4 to 6 months to file a perm, and normally a little bit longer because the initial review stage to make sure the foreign national qualifies for the minimum requirements, that usually takes about a month or so just to make sure all the details are there. If you look at the next slide, we go over just the I-140 immigrant visa petition. And David, I think you're going to talk a little bit about that.
Okay, so basically once the perm application has been approved, the next step is to file the I-140 petition. And basically the I-140, the criteria is to show, number one, that the individual actually qualifies for the position. So if the perm application requires a bachelor's degree or work experience, that you prove that you have that work experience. And the second prong is that the company has what's called the ability to pay the wage. So if the person's already being paid the prevailing wage for the position, you just show, this is the W-2 of the person. But if they don't, then there's what's called a net income test, where the company essentially has to show through their tax returns that they have enough net income to cover the person's salary. So that's basically what that petition does. It's basically an introduction to the company and sort of a confirmation of what's in the perm application, proving that the person actually qualifies. And that time again, is up to 6 months, but for many of the I-140, there's what's called premium processing, which is available where you pay the government $1,225, and then you can receive an answer within 15 days. So a lot of people will go for that premium processing, so they get an answer quickly. Then once the the I-140 is approved, lastly, there's what's called the adjustment of status. And the adjustment of status essentially is, or consular processing, is sort of to change from one status, the non-immigrant status, to the green card. Or if the person is abroad, to obtain a green card interview at a U.S. embassy abroad and then come into the United States and have the green card processed in the United States. The adjustment of status doesn't have a lot of specific criteria with respect to the company. It's more looking at the individual to make sure that the individual is healthy, doesn't have criminal record, and doesn't have any outstanding visa issues. So it's more of like a processing step. And then there's an interview sometimes, usually in the business immigration context. There's no interview for an I-45 adjustment of status pursuant to a I-140. Consular processing does have an interview if you're abroad. So basically, the regular processing time, if you look at, and this changes again every month, filing a perm in March 15th will get you adjudication sometime in October. What happens sometimes is if perm is audited, then you can get questions back from the Labor Department, and it takes a lot longer, 19 to 20 months. And then here you have a slide that talks about the time from audits to adjudication. And then if the case is denied, then you can request for reconsideration of the denial. And that's also a possibility.
I think just for a takeaway on just the last few slides and with regard to processing time priority dates, keep in mind that the priority date attaches at the time the perm is filed. So when you actually think about green card cases, remember that for certain foreign nationals, priority dates impact when they can get a green card. So the earlier you start, the earlier the priority date is attached. And the next slide, David, I think talks a little bit more about the priority date. And the last few slides, if you don't mind going to the next slide, David, the changes in the visa bulletin.
Yes, we're there.
Yeah, we just want to talk a little. We have a few minutes left, but just want to mention that there are. If you have a priority date issue, that means you're already at the point where someone had or a company had filed a green card case for you based on employment, and you are now in the process of waiting for that number to be current. The changes that have occurred recently is the government's recognized the need to find a way to allow foreign nationals that have been here a long time to be able to move forward with the last stage of the process, which basically allows them to gain employment authorization document and potentially an advanced parole that it lets them work and travel in the U.S. And the priority date number in the visa bulletin here, this is the filing date. This slide basically shows you, if you look at just China and India in the EB2 category, the filing date is the date that they actually will accept petitions. And for India, it's July 1st, 2009, and for China, it's January 1st, 2013. And if you go to the next slide, David.
Final action date here, yep.
That is the final action date. And what that means is that's the date that they're actually processing and issuing decisions on those cases. So if you look at China and India again on the EB2, it's February 1st. In contrast, it's February, the next slide, David. In contrast, it's February 1st, 2012, and for India, it's August 1st, 2006. So you can see that even if you're able to file the actual application, you're actually not gaining permanent residence until this date is current. And that's something to keep in mind for purposes of long pending applications, or people that have been here a long time and they're just stuck in the last stage of the waiting for the last stage of the process, or waiting to proceed with the last stage of the process.
So generally, if you're from India or China, because of this new rule, you could file an I-485 a little bit in advance, right? And that would maybe get you some extra benefits, including an EAD, advanced parole, and then if you wanted to port, you could port, which is another concept. Basically, allows you to change jobs if your adjustment is filed. So it's an important benefit that just was introduced just I think like 1 or 2 months ago, and it should help some Chinese and Indian nationals who are waiting for a green card get their applications in the pipeline a bit in advance. So we're a bit over. Apologize for that. If you do have any questions, you can send them to me now. I don't see any other. I've answered all the questions that we had as we went along, so I think we're okay on that end. Certainly feel free to send Barbara or myself an email with any additional questions, and we'll be happy to try to answer them. Barbara?
I think that's it for our end. If you you can contact us by email or just find us online, and we're happy to help on any immigration matters if you have questions. Thank you for attending.
Thank you for attending, and we'll be updating you with the next webinar very soon. We're trying to do these on a regular basis, and we thank all of you who have attended for coming today. Thank you.
All right, thanks a lot.
Thank you. Let's see.